First of all, would you join me in prayer? God in heaven, God of rain, God of sunshine, God of cold, God of warmth, God of us all. Thank you for being here with us this day. Thank you for leading us through life, through life's decisions, through life's journey. And we pray, Lord, as we talk today about estate planning and thoughts toward the end of life, that you would give us wisdom, that you would give us open hearts, and that you would give us freedom of thought, love, and joy as we listen to one another, as we help one another, and as we walk in the steps of Jesus Christ, in whose precious name we pray. Amen. It's a privilege for me this afternoon to be able to introduce to you two of my favorite people. Jennifer Flynn is a member of this church. She was born and raised in Charlotte and was the daughter of an attorney, so it kind of runs in her blood. She attended both Wake Forest undergraduate and law school. And since 1989, she's been in private practice here in Salisbury. At one point, she did a short stint of work, in-house work with Food Line. And then she went back into private practice. She's now broadening her choices in her career as she is working with the Wake Forest School of Law and their students there. And she's also working on limited time in her limited practice with local firm Adkins Carter. She's been doing mostly estate planning and estate administration. It's the majority of her career, along with real estate and small business work. Jennifer, we welcome you. Henry Brown grew up in Davidson, the son of the dean of the faculty and head of the economics department there at Davidson College. He was a graduate of Woodbury Forest and was a Phi Beta Kappa graduate of Davidson College with a degree in mathematics, so I'm so glad that he majored in math. Serving in the Army before he went to work with Wachovia Bank and Trust Company, which of course is no more. There he served his customers faithfully for 36 years as a trust officer in Winston-Salem, Raleigh, and in Southern Pines. Henry retired 22 years ago, and he said he hasn't looked back since. During the time that he was working, he attended various university and college classes and obtained his CPA license, all while helping to raise two daughters. The best thing that I can say about Henry, that he's been my sweetheart and my husband for almost 56 years. So please give a warm welcome to Jennifer Flynn and Henry Brown.
Good afternoon. Thank you so much for asking me to come today, and I hope you all are well. I appreciated all the kind words over the weekend, and wasn't the Lewis Preaching Series great, by the way? Just ran into several of you looking toward today. So I commend Sarah and the team, the committee here at First Pres, for realizing the need for a series like this one and putting it together with such relevant, timely, and comprehensive topics. And I heard last week's program was a great kickoff to finishing strong. So the topic that Henry and I have today is getting your legal affairs in order. So when clients come to my office to talk to me about estate planning, I often find that they are just thinking, oh, I need a will. And that's it. I'm good if I have a will. So I take a few minutes to discuss with them that while having a will is very important, and there are a lot of sad stories out there about what happens when people die without a will, there's really more to it in this arena of getting your legal affairs in order. So I take time and talk with them about kind of the big, used to be the big four, now it's kind of the big three. The first primary document that you need to have, which hopefully maybe you've had for some time, is a power of attorney. And that's where you're naming someone, the law has actually changed. We had a new Power of Attorney Act go into effect January 1st of 2018, and that person is no longer your attorney in fact, they are your agent. And there are a lot of other new pieces to the form that honestly just kind of get into a little more specifics about the different subject areas that are covered, and a lot of thought, a lot of committee work, a lot of time went into coming up with that new form, and it is purely statutory. So if you would go to an attorney's office and sign off on the new power of attorney form, it is straight from the North Carolina general statutes. So in that power of attorney, you're really naming someone to take care of the business affairs of your life, for lack of a better term. We did not make copies of these statutes for everyone. We try to be mindful and sustainable. But I will leave 2 samples up here. But basically, in the new durable general power of attorney, and does everybody know what durable means? Durable means that it survives some kind of incapacity or incompetence. So obviously, that's the kind of power of attorney you want to have, because if you're incompetent or incapacitated, it's too late to do a power of attorney. And it really talks about grants of general authority in several major areas. And I'm just going to read to you what those areas are, and then you'll get a sense of how comprehensive the document is. Real property, tangible personal property, stocks and bonds, commodities and options, working with banks and other financial institutions, the operation of an entity or a business, insurance and annuities, estates, trusts, and other beneficial interests, claims and litigation, personal and family maintenance, benefits from governmental programs or military service, retirement plans, and taxes. So those are all the areas in which you are giving your agent the ability to act if you cannot act. Most people name an agent, and then they name an alternate, a successor agent, if for some reason that person is unable or unwilling to serve. I can say personally, Ames and I recently redid all ours, and our son is now almost 28, so we decided that he was mature enough, we hope, to be our successor. So we changed those documents to name each other, and now we are naming him as our successor power of attorney, or agent, as the nomenclature is now. So we've got a durable general power of attorney. So that's basically, as I say, the business of life. And then the other thing is the healthcare power of attorney, which I assume you have all heard of. Again, the language is statutory. You are naming a healthcare agent to handle making healthcare decisions for you if you are not able to do so. The form also includes within it the living will provisions. So that's why I said it's really kind of the big 3 or 4 documents, because now they've kind of taken the healthcare power of attorney and the declaration of desire for a natural death and collapsed them into one document that addresses both. And we actually did the same thing with our healthcare power of attorney, which is interesting that we, but had some long conversations with our son before we did that, and then put his sister down as the second alternate there. But we just didn't feel like, with the ages of our parents, that we wanted them to have to make, they may not be able to make decisions like that for us, and didn't really want to choose our siblings. So you have to think long and hard. I have a lot of clients that they may have 3 children. They're like, oh my gosh, which child do I put? And so they kind of look at, and this is important, they look at the skill sets of their children, and might put the one that's more financial and business oriented as their agent on their power of attorney, and then maybe if they have a child that has some kind of a healthcare background, they put that one as their agent on the healthcare power of attorney. You can have co-agents in both settings, and I guess you just have to decide if you want to make those people have to make that decision for you together. And some people are comfortable doing that, and some are not. And so I just suggest whenever you're doing those documents that you talk to whoever you're going to name and make sure they are comfortable taking on that role. So what do you think is the last big document you should have? I can't hear you. A will, that's right. So in North Carolina, if you die without a will, the law decides about everything. So by not having a will, you are giving up control of how you want your assets distributed upon your death and who you want to administer them. And I think Henry's going to touch on a little bit about some decisions around those choices when he speaks, because he has some more insights into sometimes you get into a situation where maybe the best person wasn't chosen to be doing that job. So let me I'm going to pull my notes here for a minute. So a will expresses your testamentary intent, where you need to know the nature and extent of your property and who the natural people would be that you would leave your things to. That is the amount of competence that is required to execute a will. It is not the same amount of competence that is required to execute other documents, but it's really knowing the nature and extent of your property and who the natural beneficiaries of that property would be. And as I kind of hinted at, you really need to think about your family dynamics in appointing the executor. In fact, I recently got some information from a continuing ed conference that someone went to, and I thought it was interesting. They had a list of the top 10 executor mistakes. And I thought this might be some good food for thought for you to think about who's not going to maybe make those mistakes. Hopefully, if you already have a will, and hopefully you do, your executor will fulfill these requirements. But the top mistake is failure to file documentation with the clerk's office or the IRS in a timely manner. Number 2, the failure to prudently invest estate property. Number 3, the failure to eliminate unnecessary cost or expense. Number 4, the failure to treat beneficiaries fairly. Failure to wait to distribute things in a timely manner, or just not distributing things at all. Failure to communicate to beneficiaries. Failure to use the best option in estate administration. And there's a full-blown estate administration, which a lot of you may be familiar with. I wouldn't be surprised if some of you have had to administer estates yourselves. But there also are some shortcut administrations that you can do either through the clerk. There's one called summary administration. There's some different names, and it's really based on the assets and the extent of them and the nature of them. And you can sometimes go through a shorter process. So people aren't aware of those and do a full-blown administration, which can end up taking a lot more time and money. Failure to actually follow what the will says is number 9. And then number 10 is failure to provide vouchers. And by that, I mean supporting documentation. I mean, when you file accountings with the clerk, you have to show bills. You have to show your account statements where the checks went out. You have to show receipts. They definitely want to see that the funeral bill was paid. So those are kind of the top things. You obviously really need a very organized somewhat business, I'm not going to say financially minded person, but more of a business-oriented, logical person to do that. And then the other thing that you need to think about when you're working on your estate plan is beyond, I want this ring to go to my daughter, I want this bracelet to go to somebody, who my car goes to, where certain money, certain real estate goes. You also need to think about, do I want to make any kind of charitable contributions? Do a lot of people leave money to their churches? And I know our church is, I think, looking at being a little more mindful of that and doing some work with the congregation in that regard, but also nonprofits. A lot of people leave money to their universities or their colleges. And again, in a will, you have that opportunity to do that if you want to do so. If you die without a will, you lose that opportunity. So let me just give you a little example of what happens when you die without a will. Okay. North Carolina, we have what's called the Intestate Succession Act, and I always have to read from this because I don't ever remember it because the percentages are very different based on kind of the status. So if someone dies, and that's the decedent, survived by a spouse with no children, but one or more of their parents is living, then the surviving spouse only gets half. The surviving spouse gets half of the decedent's real estate and the first $100,000 of the personal property and one half of whatever else is left of the personal property. The other half of the real estate, the balance of the personal property, goes to the parents, to the in-laws. So just consider the impact if someone dies and their parents are very wealthy and they get more wealth and their spouse does not get as much. Would the decedent maybe wanted a significant portion of their estate to pass to the wealthy parents and to their surviving spouse? Probably not, but that's what the law provides. And I'm gonna give you one more example. If a decedent is survived by a spouse and only one child, and it gets a little complicated at this point, maybe that child's deceased, but they have children, so they're stepping in the place of their parent. The surviving spouse, again, gets one half of the real estate and the first $60,000 of the personal property and one half of what's left of the personal property. So the remaining real and personal property pass to that child or that child's descendants. And these percentages change as the number of children increases. And if you die and you don't have a spouse or children, everything goes to your parents. So the law is going to take care of it for you if you don't get a will. So the biggest advantage there, like I said, is that you're in control. You can say who you want your assets to go to, especially if it's beyond your immediate people in your family, and who you want to administer it. Because the law has set up statutes that give a certain period of time for a list of qualified people to come in and seek to administer your estate versus it being the person that you have named to do it. So those are just kind of the advantages and disadvantages when you get into wills. So I want to just take a minute and talk about your notebooks. And you all have a table of contents at the beginning of that notebook. And I think this is not my idea, this notebook. I have a very good friend who was very generous in sharing her materials with Sarah and the committee and me, whose husband was diagnosed with cancer in his 50s. And she's a very organized person. She has all these bins in her attic, and they're all labeled. And I mean, if you want something organized, she can take care of it for you. But they had the benefit of time while he was fighting his cancer. They had about 2 years. And so she came up with this plan for this notebook, and it is not a new thing. But it's honestly something I had not thought about. And I have since given the table of contents and a notebook to my parents. And that's what I suggest. If you do a notebook, give it to your children, or make sure they know where it is. Make sure they know where these important documents are, because you don't want to be, someone is deceased and they're frantically running around the house looking for the will. That's not where you want people. People need time to grieve, and that was really her purpose in working on this notebook. And she's since given it to several people and come up with her own notebooks, and I think they're getting ready to do another round at, she's at St. John's, of this kind of a series like we're doing. But so the first thing is your income, having information in your notebook about your income, pay stubs, Social Security, disability, maybe what you get from a 401k, retirement, other sources every month. Some specifics on those 401k and your investments, information on your life insurance, all your other insurances, your homeowner's car, if you have a boat, any other miscellaneous umbrella policies, jewelry, everything about your bank, your financial statements, checking, savings, safety deposit box, lines of credit, loan information. And as far as when we talk about all these accounts, what else is really important to put in this list? Anybody think? Because everything's done online now, what are they going to need to have? They got to have all your passwords. Can't do much if they don't have your passwords. List of all your medications, the information about your health insurance or the Medicare, all your doctors. Who are your doctors? Who do you see? What do you see them for? Any just miscellaneous bills, most of which will probably be related to the home. And then you hit your legal documents. And those you need to have, and even if, now I would not suggest that your original legal documents be in this notebook, but copies. But your original documents need to be in a safe place. A lot of people put them in safe deposit boxes. The only thing I would say about safe deposit boxes, and Henry may mention this as well, is unless you know where your executor or someone in the family knows where that key is and can go as soon as something happens and open it and get it out, the clerk's not going to let you go in it until they go over there with you. But a lot of people are now having safes in their homes where you could put these documents. I've even heard people say they put them in their freezer because it's fireproof. They just need to know where that power of attorney, that healthcare power of attorney, where your will, where they are located. And then the other important documents, any deeds to your home, vehicle titles, your marriage license, your birth certificates, military discharge papers, Social Security cards. It's just helpful if this is all in one place. And the last thing you can do, and I know you're going to be talking about this, I think, it's a funeral. Is it next week when we talk about funeral? The last week before? Again, that's something that you can now have control over, how you want your funeral to go. And so you can go ahead and put in this notebook your funeral plans, what funeral home you've chosen, whether you want to be buried or you want to use the columbarium, what other notification, what you want your obituary to say. All of that you can put in there. And these are not easy things to think about, but you really have to think about the alternative, which is you're not having any choice about it if you don't do it. And that burden is on your grieving family to immediately have to make all these decisions and do all these things. One thing I didn't mention, on the power of attorneys, a lot of those are recorded at the Register of Deeds office. The new Power of Attorney Act does not specifically require that, except if it's being used to transfer real estate, because deeds are recorded at Register of Deeds. Someone's got to see that an agent had the authority to do that, so it's recorded in that circumstance. But you still may have, especially financial institutions, preferring you to record those if you are regularly using it. on behalf of the principal. So I just wanted to note that. Yes. Right. They just hand it over. Yeah, like I said, if you, I mean, again, that's not something you may want to do, although I have, I had my students at Wake Forest in a session with Brad Wilson, who's the former CEO of Blue Cross Blue Shield, about 2 weeks ago. And he was talking to them about leadership and about really, thinking about what they wanted, what kind of people they wanted to be. And he said the best way you can put your finger on that is write your own obituary. So he was telling these 25-year-old students to write their own obituary. So it is not, it shouldn't be that foreign of a concept to us to do that. Are there any other questions? I know I talk kind of quickly and I apologize. Oh, okay. Oh, for y'all. Oh, okay, okay.
Thank you. I currently have durable power of attorney, my will and all that, but it was done several years ago. Do you recommend I redo my healthcare power of attorney and my durable regular power of attorney?
They are, they are still good.
Okay, but they're not the new
They're not the
forms.
current form, but
Okay,
if you executed the old form before January 1st of 2018,
yes.
you're grandfathered in,
Okay.
basically. And we
Okay.
see wills, unless you just want to change something drastic.
Okay.
You really don't need to change a will.
Okay.
And I think someone had mentioned to me that most form, the medical order for scope of treatment, and that may be something Derry's going to talk about when
Yeah.
she does her thing, because that is truly medical oriented. That really is not on this legal side of things. It kind of amplifies in some way, but then on the other side, the healthcare power of attorney amplifies in some ways as well. Yeah, so y'all going to cover that later.
Thank you.
Yes, and now I'm going to segue, because, oh yeah, we can do more questions at the end. So I've kind of we've talked a lot about estate planning. And so once someone has died, you then have to go through the estate administration process. And Henry's going to talk to you a little bit about that, and I may chime in as we go along.
Thank you, Jennifer, and thanks to each of you for being here this afternoon. Can you hear me okay? A little bit about myself. I was a trust officer at Wachovia Bank. If those of you that can think back to the late 1990s can remember Wachovia Bank, I retired in 1998, 22 years ago, and a lot has changed since then. But hopefully, some of the essentials, most of the essentials that Jennifer and I will be talking about have not changed. I'll be covering some of the same things that she just finished talking about. So I hope that what I have to say will complement her and not contradict her in any way. So if I'm out of date, Jennifer, please let me know. Estate administration was a very interesting part of my work as a trust officer at the bank all those years. To start out on maybe a tongue-in-cheek light side of things, there are a few truisms that I found to be the case over the years that I applied this trade. First of all, there is no such thing as a simple estate. Every estate has got some element of complexity to it, something that makes it unique, that makes it different from all the others. So you can't just lump all these things together. Another is tangible personal property. the dining room table, that chair that Great Aunt Susie embroidered, something that your grandfather left you. Those are things that are very special, and if they are not handled properly and with the right kind of respect, they can frequently cause problems or trouble. Just keep that in mind. Another one that sometimes hurts, but sometimes is the truth. Be wary of two classes of people. One is in-laws, the other is grandchildren. Just keep these in mind. They're fine folks, every one of them, but they have their own personalities that you have to be aware of and work through. And lastly, the one that I love, sell everything that eats. I had a firsthand experience with this in an estate that I had. It was a medical person whose hobby was to have a small herd of cattle on the outside of town. And one of the first things that we had to do at his estate was to sell that herd of cattle. Well, wouldn't you know that the night before the sale, one of those cows got out of the fence and was wandering around the road and got struck by a vehicle. And boy, the stuff that we got into because of that was a dear lesson to be learned. So sometimes you can't do that quickly enough to sell everything that eats, but that's something to keep in mind. A lot of what Jennifer said, I'll repeat in one form or another when it comes to estate planning and estate administration. So I think in this case, the duplication or the repetition will be helpful to us. Regarding estate planning, don't just think about it, but do think about it, and then do something. Have these things in mind, but don't just sit there and say, yeah, well, I'll do that tomorrow, next week, or the next time I see my attorney, or the next time the kids come to town. Make up your mind that you want to do something. It's very important. Discuss these plans with others that are involved. If you're married, with your spouse. If you have children, with those children. With any other beneficiaries of the estate. Your brother, your sister-in-law, who knows who, your next-door neighbor. These are all people that have distinct personalities, and you need to have their uniqueness in mind as you think about them in terms of your estate plan. Of course, you want to discuss these things with your attorney, too. You can't get up to bat, really, unless you have a good attorney to represent you and to prepare your will for you. So make your selection carefully there. It's helpful, too, to have someone who's familiar with your tax work, bookkeeping. If you have a CPA, an accountant, or someone who keeps books for you, fine. If you do it yourself, make sure that you know that you're right on top of your own stuff all the time. Business associates, anyone who's worked with you, or who used to work with you, or who knows your ins and outs and everything. These are people that frequently can be called on for help or advice, or simply to be informed of what you're doing. Once you've come up with a plan, don't just file it away and say, well, that's done with, now I can get on to what I want to do next. You need to review that periodically. As things happen in your life, as people come and go, as new grandchildren come along, as someone dies, as someone moves out of town, if you move to a different location, these are all things that could trigger a subsequent review to a plan that you've made. So don't think that once you've taken that step, it's all over with. It needs to be kept in mind and reviewed constantly and revised and updated as you think appropriate. And Jennifer touched on this. Once you've got your will or other documents in good form, put them in a safe place. A lot of people put their wills and things like that in their lockbox. That's good, but make sure that people know that they're in the lockbox, and make sure that they know where the key to that lockbox is. Don't just stick that in the back of the third drawer or something like that and say, well, nobody will ever need that. It's right here and I can get it if I need to. But if you are not there, someone else has got to do that. So make sure that somebody else knows where you have your stuff, your important papers, and how to access them. Keep in mind, Jennifer mentioned this too, that at the time of death, if a person does have a lockbox, that lockbox is sealed and is opened only by a representative of the clerk of court who comes to inventory the contents of that box. So don't have anything in there that will be needed at the time of or immediately following your death, because nobody will be able to get to it. As you plan your estate, be mindful of all of the different assets that you may own. The federal estate tax return lists some 6 or 8 categories of property, and the primary ones you're familiar with, but just let these go through your mind and say, do I have any of this? Or yeah, I used to have some of that, or yeah, we've got a few of those, but keep these in mind. The first is real estate, your home place, that farm out in the country, the business that you own. Whatever is real property, that, whether it's in your name or jointly held, that will be an asset to be accounted for in your estate. Securities, stocks and bonds. Many people have this type of asset. Easy to keep track of, easy to know about, easy to follow, but just be mindful that you've got to have all the jots and tittles for what those things are, stocks and bonds, securities. A third is cash items, mortgages, notes that you might have in cash, cash accounts, bank accounts, savings accounts, certificates of deposit, those types of things. These are all assets of your estate. The fourth is life insurance. Life insurance on your life, of course. But keep in mind, too, that if you are the owner of a life insurance on someone else, that may have estate tax consequences in your estate, too. Jointly owned property. Don't think that just because A and B appear together as the joint owners of a piece of property or account somewhere or a certificate of stock somewhere, that will be included in your estate and at least accounted for. This, compare this to items over which you may have a power of attorney, where I have this power with respect to someone else's property. Be real careful about how you get into those arrangements. And then, of course, there's the miscellaneous property. Anything that doesn't fall into any of the other categories will be classified as miscellaneous. Those are the primary types of property that most estates will have. So you need to think through those thoughtfully, be aware of them as you plan your estate. Who should this pass to? Uh-oh, I don't want that to be here. I better sell that before my death occurs. Just keep it in mind and how it's eventually going to be handled. Keep in mind that at a person's death, all of the assets that person owns, accounts in that name, are closed, and those assets are re-established and re-registered in the name of the personal representative of that person's estate, the executor or the administrator of that person's estate. This does a lot of things. It simplifies it, first of all, by taking it out of the name of the decedent, so that there's a definite line when those books are closed, and the personal representative picks up and goes on from that point. So that is a step that needs to be taken promptly as soon as the administration of the estate is underway. One of the first things that an executor or an administrator does, of course, is when a notice is published in the newspaper. You've probably seen these. Shortly after the person qualifies as executor, a notice to creditors, so-called, is placed in the newspaper and is run there for a period of time. And that's notice to the world that, hey, so-and-so has died, and if you have a claim against this person or his estate, you better come forward with it now so it can be satisfied and paid from the estate. So make sure that this is done. Funeral expenses, of course, these will be covered later in this series in more detail, but this, of course, is a typical expense that's incurred in most estates and is one of the first things that needs to be paid. The simple expenses of the estate administration, of course, also are legitimate charges against the estate. Fees that are charged by the court, by the clerk of court's office for the process of filing and accounting and everything. If you have to get property appraised, you have to pay the appraiser. This is an expense of administration. Any expense that's incurred simply because you're doing your duty and administering this person's estate is a legitimate charge against the estate and must be paid out of the estate funds. And of course, taxes, inheritance taxes and estate taxes. I said that I worked with Wachovia through 1998. Jennifer was telling me that I was talking about the inheritance tax returns, and back in my day, there was the federal estate tax return and also a North Carolina inheritance tax return. Well, I think she said since 2013, the North Carolina inheritance tax return is no more, and I guess they get a cut of the federal estate tax. But anyhow, that's a charge. North Carolina's going to get its part, I'm sure, it's one way or the other. But the federal estate tax return is very definitely there. That's made up in 9 different categories of assets that are in that return that help the executor to make sure everything is listed in the estate. Those taxes are due, I think, still due 9 months from the date of death.
Date of death, yes.
9 months from the date of death, the death taxes are due. So if that turns out to be a significant amount, that's one of the first things that the executive's got to do, of course, is to marshal the assets of the estate at the beginning and say, okay, what can we liquidate to raise that much money and have that available to pay when the time comes to do that.
I
So-
think you can pretty easily get an initial extension on that, because that 9 months can pass very quickly.
The reports that the executive has got to file, of course, the first thing that he does with the aid of the estate's attorney is to probate the decedent's will, to present the will as the last will of the person who has died. This can be drawn, hopefully will have been drawn, by a practicing attorney who knows what they're doing so that the will can be properly done. But there's also holographic wills, handwritten wills that people can do on the back of an envelope if they want to. It's taken all kinds of forms, and as you can imagine, can possibly raise all kinds of questions too. So have you had any experience with some of those that you can speak to?
Yes, please don't do that. So in North Carolina, we have a will and solemn form that's admitted to probate is self-proving if it's signed by 2 witnesses and a notary, which is really another reason for having someone assist you in these documents, because the same formalities are required with the healthcare power of attorney as well. A power of attorney just requires a notary, but both the healthcare power of attorney and the will require 2 witnesses and a notary, which an office can provide. With a holographic will, you have to bring in witnesses that sign off on affidavits that know the handwriting of the decedent. And sometimes it's really hard to find those people. So there's just a lot more affidavits and things you have to come up with if you don't have that kind of self-proving will that is required. And the problem also with a lot of, and I'm sorry, I keep saying, with a lot of the holographic wills is they don't take care of everything. So then it becomes what's called an administration CTA, where some of the property goes by will and some of it goes by intestate succession. So it's just very, there's also it's been a long time since I said this word, non-cupative wills, which is where someone on their deathbed says their will, and someone takes notes. And of course, there's a whole other host of requirements surrounding something like that being admitted to probate. So,
Thank you, Jennifer. During the first 90 days, of course, is when the executive does most of his work. He'll gathering the estate assets, making sure that he has all the claims against the estate in front of him to be paid. And at the end of the first 3 months, the clerk of court requires what they call a 90-day inventory. That is a more complete and precise inventory and valuation of the estate's assets. It all works toward that 90-day inventory. So that is one of the most important things that the executive does.
that's the point where you have to start paying money to the clerk. It's $120 to be issued letters, and then it's $4 per thousand on personal property. But in North Carolina, there's a cap at $3,000. So the probate costs don't end up being too exorbitant in North Carolina, at least.
Okay. After the inventory is filed and the tax returns are filed in 9 months, the annual accountings on the anniversary of the qualification date as executor or administrator are due in the clerk's office for as long as the estate is under active administration. Typically, this may run for anywhere from 1 to 3 years, depending on the nature and complexity of the estate and its assets. But most estates, the ones that I was handled and worked with in my time, we were able to conclude within a 2 or 3 year period. There'll be exceptions to that, of course, some that can be done much more quickly, others that will be a little bit more protracted. But as long as the estate is open and under active administration, there is still a requirement for the annual accounting with the clerk's office of the clerk of court.
And I will say that this process, which probably majority of the people have to use, is a full-blown administration. There are some other shortcut ways I referenced earlier that could be applicable in certain cases.
Okay, thank you. Of course, one of the, as I think I already mentioned, that one of the first things that you do is to file the final personal return for the decedent for whatever portion of the year that person lived. And then thereafter, during the course of administration of the estate, the personal representative, the executor, files a fiduciary or trustee type of income tax return. After you've done all that, paid your taxes, filed your accountings, distributed what you have, then it's time to close the estate. You've done your job, you finished. The tax returns have been accepted, everything's paid, all the debts are paid, cost of administration, you've met the cash bequests and specific bequests. So then you go to the residuary provisions in the will. It says, okay, now that you're down to this, what do you do with what you got left? Well, you give those to the remainder beneficiaries, family in most cases, but whoever it is, will receive the residuary estate. And once that's completed, your job is done, and you file your final accounting to the beneficiaries of the estate and to the court, and you're all through. As I said, that could take anywhere from 1 to 3 years in most cases, but it could be shorter, it could be more protracted, depending on the complexity of that. That, in an expanded nutshell, is kind of what an estate administration entails. A couple of things to keep in mind that as I made up my own notes, thoughts that came to mind, experiences that I had, some that I wish I hadn't, some that I'm glad I did, but some that are hopefully worth passing on. As you think of your own planning now, be mindful of the people in your life. Who are the people in your life? Who means the most to you? Who has meant the most to you over the years and right this minute? Have those in mind as you make your plans. Think about the property that you own. Jennifer and I have gone through the types of property: real estate, securities, cash, insurance, all those things. Think about everything, I mean everything that you own. Because After your death, you don't own it anymore, and somebody else is going to. So it's helpful for you to let your executor know what those things are. Make sure that you account for everything. Know your beneficiaries. Know their strengths, their weaknesses, their peculiarities, what makes them different, what endears them to you, what makes you think, Just be aware of who you're talking about. And help your executor and these people administering your estate to avoid surprises. This refers not only to assets in your estate, but also to the people involved. And again, do all these things now. Don't wait till next week or next month or 4 years from now. Have it in mind and do something about it now. Don't put it off indefinitely. It's much better to do it that way. One other thing I should have mentioned, that in terms of income that you might receive from a pension or an annuity or something like that, it obviously will stop coming to you at the time of your death, but it may continue on for somebody else. Make sure that the executor knows about the source of that annuity or that payment, so that can be handled appropriately in the estate. And mercifully, I've come to the end of my notes on that. That hits most of the high spots that I recall from my days, but thank you for listening to me and to what we've had to say. Jennifer, back
Yeah, I
to
would
you.
just reiterate what you said about, remember who those people are that are closest to you, the people that are important to you, because it will be a true blessing to them for you to do your notebook. It will also, I think, take a lot off your mind to have all that in one place so that you know where it is, but also that they know where it is and that they can easily go find those things. Because I'll deal with a lot of people who come in and they just give me a box full of insurance policies and statements and then they come to us because we can help them sort through it because it's truly overwhelming. And then, I recently helped a woman handle her husband's estate. She died. I helped her son handle her estate, and then his brother died, and I just closed his estate. But then we had to reopen Mom's estate because they became aware of something they didn't know about. So as organized as you can be while you're able to be organized will be a blessing to your family. And I would also just encourage you to remind your children that they need to do these things as well. So thank y'all and blessings. Any questions, Kim?
Hi. I am unclear about right of survivorship on joint accounts and safe deposit box in North Carolina.
I can't really speak to safe deposit boxes. I have one. I assume that it would go to either one of us if the other was not there. But accounts with right of survivorship and anything that has a designated beneficiary. That could be life insurance, that could be some kind of retirement annuity, that could be anything that has a designated beneficiary or someone else survives to the whole of it. That is considered theirs upon death, but they are going to have to submit at least a death certificate to get those documents, but they may also have to submit, just everybody has their own requirements, letters of administration or letters testamentary, and that's where that's the golden ticket for your executor or administrator to hand over that says, I have the authority to change this title to get into this account. One thing that Henry and I talked about when we met last week Was it the week before that? I can't remember. Maybe it was last week. That you really cannot open an estate till you have the death certificate. And that can take some time for the funeral home to work through that process. And you just kind of have to wait.
Thank you for raising that question, and that just points out again that the importance of making certain that your property is titled as you want it to be titled, and that it will pass in the direction or to the person that you intend for it to go to.
Nothing was, oh, sorry. No, I'm loud. Nothing was said about Social Security being contacted, and that is an absolute necessity because I have a family member who got in a lot of trouble for not letting them know that her father had died and she was still receiving checks.
And then you got to refund them all.
Oh, yes.
I just had that happen in a state with significant pension monies. And no, Henry mentioned you need to have the information on where that is coming from because it took about 6 months to figure out exactly where that was coming from.
And it is incumbent upon the survivor to make that clear to Social Security.
Or the executor, whoever's administering the estate.
Thank you, Carl.
Yes, thank you.
There's one more document in the process. Henry, you talked about stocks and equities and those things. If you need to sell stocks in the estate process, you will need to go to the bank and get what's called a medallion. And that's done through the bank, and it's a different kind of thing. It's not a notary. And you need to talk to your local banker about that.
Yes, some do require a medallion signature, and it is a level above notary, and they'll just have to tell you if they require it or not, because it's kind of across the board with some do, some don't. Yeah, they may not. Yeah, not everybody does it anymore. They don't even all have notaries anymore, so, or certain times of day they don't.
Should we think about right of survivorship for our bank accounts so that there is cash available? I'm talking about the second of our deaths, but so there's cash available to the executor to take care
At
of.
least initially.
Yeah.
I don't want to get too detailed about the forms, and actually we do have some of the forms for opening an estate available. I'm going to put it on the table here if you want to look at them before you leave. But when you fill out the inventory, there's actually 3 parts to the inventory form. And one is, it's after the 90 days when you've been able to make an assessment of actually what you have. They talk about property of the estate in the first category, and that deals with accounts in the sole name of the decedent, joint accounts without right of survivorship, stocks and bonds in their sole name, or again, jointly owned without right of survivorship, cash and undeposited checks, other tangible personal property like vehicles, and then they actually have a category for real estate willed to the estate, which doesn't really happen very often. So that is really part of the probate estate, what goes through probate with the clerk's office. The second page has part 2, which is property which can be added to the estate if needed to pay claims. If needed to pay claims. So if it's not needed, it's not going to ever be seen again after this initial form. And that is joint accounts with right or survivorship. Stocks, bonds, securities jointly owned with right or survivorship. And then real estate property, entirety is property, which is husband and wife property, which is basically survivorship. Life estate and some other kinds of property. So yes, by doing survivorship, it automatically makes that money available to the surviving spouse or the surviving tenant of that surviving account holder. But that doesn't mean it can't potentially be pulled back in if there's not enough money to pay the debts and claims of the estate.
That's a very good question. Just keep in mind that every estate is going to have expenses that have got to be paid. and that money has got to come from somewhere. So make it easy on your executor by having some that he can have access to. Excuse me?
And then they'll have to open an estate account. Yeah.
Jim,
We live, hello. We live here, and we have property in Virginia, and one of us dies. Do we file in Carolina, or do we file in Virginia, or do we have to file in both?
Usually the estate is opened in the county where you're domiciled at the time of your death. So it would be opened here, but then exemplified copies of all the estate documents here would be sent to that county in Virginia where the real estate is. I just did that same estate that I talked about with all the three different estates. The parents owned property in Allegheny County. So once I closed the estates here, we had to send, within North Carolina, we have to send true copies, which is a little lesser than an exemplified copy. But I had to send each estate true copies to Allegheny County so that someone doing title work there could see the chain of title and what happened with the real estate.
Jennifer, hey. Going back to the right of survivorship, I hear so often some people say on a checking account, if it's a joint checking account, it should say Jennifer and Ames or Jennifer or Ames. And should you go ahead and have your executor's name put on the checking account?
I wouldn't do that, no.
I just went through this with my husband who died. And one of the biggest shocks I got was going to DMV. We had just gotten a new car. He had Parkinson's, so he wasn't driving anymore. And I tried to put the car in my name only. And they asked me for $600 and some taxes. And I said, whoa, I've already paid them. And she said, if you make any change on your title, you have to pay taxes again. So check your title, because North Carolina now has a right of survival on the new titles. But if you have an older title, they're going to ask you to pay taxes again on that vehicle.
I haven't, Jennifer, I haven't heard this said specifically, but I sense that whoever happens to be the executor of an estate, that executor knows the person's personal attorney, and that they contact that attorney immediately for guidance. What's your view on that?
Well, they're only going to know if you've told them. But typically, I mean, there's no requirement or expectation that whoever drafts your documents will help you, represent you in administering the estate. I mean, that's not something that I ever expect someone to do, and we ethically can't expect people to do that. That's really why we don't keep wills in offices anymore. Lawyers used to keep those documents in their offices, but then it kind of almost made the executors have to come to you to minister the estate, and that is not ethical. So we do not do that. But yes, oftentimes the children are aware of who kind of the family attorney was, and they go to that person and say, can you help us administer the estate?
Jennifer, can a co-executor to the estate here in North Carolina, can a co-executor live out of state if the executor is in state?
Well, when you say co-executor, do you mean like they're two? Yeah, I had a state idea. One of the sisters was, I think, in Kannapolis, and the other one was in New York. And, but I still had to send everything to her to sign. But at least, but if there is an executor that is out of state, and that's the only one, you have to name a resident process agent, and that's just a form with the clerk's office. And sometimes it's, if there's an attorney helping them, sometimes it's the attorney or someone they know that can accept process in this state on behalf of the estate.
Just 1 minute. Just 1 minute, please.
I think many of us in here will end up being an executor or an executrix, having done my parents' estate. After following all the rules and closing everything out and paying all the bills, 5 years later, a friend of mine happened to be on the Secretary of State's website for unclaimed property. And lo and behold, there were 3 or 4 things from my dad's estate that were either dividend or interest or things that had come in long after the estate had been closed. So I had to reopen and then submit a massive amount of paper to the state to claim the additional property. But that's something that everybody probably should be aware of.
Yeah, that's a really good point, Doug. I would suggest if you are administering a state, just go on the Secretary of State's, even if it's another state, go on their escheat division part of the website and just put in names, put in different ways to put the name, and you'll be surprised what may come up. And then there is a process to get that money back. But yeah, you may necessitate opening an estate, reopening, which is not a huge issue, but it's just still another thing you have to do.
Very good point. As part of the planning that should go into all of this, if the if the decedent, if the testator, we'll say, has property that maybe nobody knows about with him, don't keep secrets. Let somebody know that you've got to own a piece of land out in Arizona or something like that that nobody else knows about, so that you avoid the kind of surprise that the gentleman just mentioned.
Excuse me. Yeah, just an idea that someone I was talking with tossed out, and he just happened to say, we were talking about funeral expenses or funeral plots or something, and he said that they put a lot of this type of information on flash drives and gave them to both of their children. Now, how much and how extensive that information was on the flash drive, we didn't go that far. But anyway, just as all, I thought it was, a nice idea. Now, have we done that yet? No, but it's an idea.
What Jennifer was trying to say, it's a more modern version for those of us who are computer savvy. I have one question, and then that sometimes there's an elephant in the living room, and the reality is that our divorce rate, I can't remember, it's over 50. So do you have any advice for second families or anything that we need to think about when they're doing wills?
Typically, well, I'm not going to say typically, because I do not do family law. Oftentimes, there is some kind of a prenuptial agreement done that kind of deals with those issues when there's a second marriage. Because short of a will having some kind of a trust provision that provides for the surviving spouse until some set other event may happen, then you're in a situation where the surviving spouse could make a whole new will and could leave everything to the second husband or second wife. They could leave stuff to the joint children. So there are things you can do within your will or even outside your will from a trust standpoint, which is really one of the primary reasons people do trust anymore. With the tax exclusion rate at like 11 million, most people don't need to worry about tax planning, but which I do not do. Just give myself a little disclaimer there. But trusts are private documents versus the public document of a will once you die, and it goes through the administration with the clerk's office. But that's really between a prenup or even a postnuptial agreement, those are really and doing some kind of trust that kind of tie it up if that spouse should remarry, so that you insure it for your children. And also making sure that those assets that are outside the probate estate, the ones where you name a beneficiary, that those are named for the people you want to make sure get something. So there are different safeguards you can do there. It just kind of depends on what works for you.
Okay, thank you. That's helpful. Glenn, did you have one question?
I really have two questions, and the one that most concerns me is how do I choose an attorney since I moved from Virginia and haven't looked for attorneys. But we have a will that was drawn with an executor in Virginia. We have no follow-up documents, whatever you were saying. I did not get that written down about how I make the will from Virginia valid for use in North Carolina, and whether the executor has any power.
I mean, a lot of people die here with wills from other states. It just would be the same process. Is it self-proving? If not, then we go through the process of what would make it be acceptable to be probated. And then if there's an out-of-state executor, then there's going to be a resident process agent appointed.
Thank you so much for being here. If there's any message, those of you who are far ahead of the cooks, review what you've done. And those of us, just 1 minute, and those of us who hadn't gotten started, the best gift we can give our children or those who we are leaving this responsibility with is let's get to work and hold each other accountable. I'm going to ask you, how you doing on your notebook? So we'll see you next week. Dr. Randy Kirby is going to be here, and he's going to talk about the emotional challenges of aging. And I have had a sister-in-law die and a good friend die. The challenges of this age are extraordinary. So we're going to talk about them and get help next week. So, and Missy wanted to say something, but remember to pick up the estate planning in the back.
I don't know how many of you read Senior Savvy. I pick one up every month and read it from cover to cover. I always find some sort of bon mot or a poem that just fits the situation. And back in October, there was a wonderful article, and this has really nothing to do about trusts and estates, except part of your notebook needs to include memories. Your memories of who you are, who you were. What were your parents like? What were your grandparents like? What was it like to handle those ration books in World War II? What kind of travel did your great-grandparents do? Write these things down. One weekend, several years ago, when my grandchildren were a whole lot younger, my two grandsons, we were taking them to Southern Pines with us. And one of the boys asked me a question, and for an hour and 45 minutes, we talked about memories of what Henry and I went through as children or dating or whatever. And when I got home, I wrote it all down. I still have a copy of it. So I challenge you, I challenge myself. Part of that notebook, write down some of your favorite memories. Your children, your grandchildren, your great-grandchildren, years and years from now, will love reading about those old things when we didn't have TV and we didn't have iPhones and all these things that we've got today that kids are looking like this too. Write them down. Your kids will love them. So will your great-grandchildren.
Thank you, Jennifer and Henry.